Council seeks permission to address the bench individually as your lordship and collectively as a bench. The Council A for the petitioner will be dealing with issue 1 and 2, while my co-counsel B shall be dealing with issue 3 and 4. The time frame for the same is that co-counsel A shall utilize 12 minutes, while my co-counsel B shall utilize 12 minutes, reserving 3 minutes for rebuttal and 3 minutes for rebuttal. Oh, much obliged, Your Lordship. If there's no further clarification, the Council seeks permission to proceed with the statement of facts. Indeed, Your Lordship. Indeed, Your Lordship. The petitioner, this Indian Legal Service Center, and the UGC challenged the recent amendments held in the Advocates Act 1964. Lordship, 1961, introduced by the Union Law Minister of India. These changes violate the constitutional limits, undermine the UGC's authority in education, and impose.
Number 1 and 2.
Indeed, Your Lordship. Indeed, Your Lordship. Yes, Your Lordship. And impose arbitrary restrictions on the law graduates. Further, these amendments impact access to profession, disregarding economic disparities, and establish legal education standards. Hence, the petitioners seek the Honorable Court's intervention to strike down the impugned provisions as unconstitutional and ultra-virus. Your Lordship, if there is no further clarification, the Council seeks permission to advance with the argument. Much obliged, Your Lordship. Your Lordship, the issue 1 states whether the petition is admissible. Your Lordship, the petitioner humbly submits that the present writ petition is maintainable before the Honorable Supreme Court of this India, as it raises a substantial question of the interpretation of a statute and a constitutional right. Your Lordship, the petitioner satisfy the prerequisites for invoking the jurisdiction for the Honorable Court under Article 32 of this Indian Constitution. As Article 32 grants the power to enforce the fundamental rights as it is a guaranteed remedy under the Constitution, Part 3 of the Constitution. The petitioner has locus standi under Article 32. However, with the advent of PIL, the doctrine allows the organizations to represent the argued facts. Your Lordship, it's a petition.
Or the NGO?
Your Lordship, it's a case where the UGC and the NGO has been merged, Your Lordship.
So, first you are going to address with regard to the NGO alone?
Indeed, Your Lordship. Yes. Your Lordship, the PIL can be invoked and the same will be reiterated in the further arguments. And the primary test for the locus standi involves whether the petition has a direct legal interest. Your Lordship, the petitioner has a direct legal interest in the current case as it directly impacts the statutory function and responsibilities. Further, it has a legitimate connection as there is constitutional violation of mainly right to equality under Article 14, right to practice any profession under Article 19(1)(g). Your Lordship, the Council humbly submits that in the case of People's Union
of the constitution of your association.
Pardon, Your Lordship.
You are representing an NGO.
Indeed.
What's the constitution? How come you are representing an budding lawyers and other things?
Your Lordship, the same is being reiterated in the very next argument, Your Lordship. Your Lordship, the Council for the petition uses the case of the People's Union for Democratic Rights versus Union of India, 1982 AR 1473. Under this, it held that PILs are vital mechanisms to ensure access to justice. And Your Lordship, also the case of Bandhuva Mukti Morsha versus the Union of India, for which the citation is not available as it is only per se for argument's sake, where it was held that organizations, social organizations with a public fire to protect the interest of the aggrieved parties can represent the facts when there is a public interest matter involved in the present case. Your Lordship, the SLSC, that is the Indian Legal, is representing the aggrieved parties, that is the students, the legal professionals and the institutions, Your Lordship.
Why not the students come up before this court? Why you are being an association? Why you are coming?
Your Lordship, the reason...
Your role?
The NGO over here is representing the students as a whole, as they are, Your Lordship.
So you are a student organization?
Not a particular student organization, but an organization which stands for the legal fraternity, Your Lordship. So it is representing the law student, not only the law students, but also the professionals, institution in a representative capacity, Your Lordship.
How are you affected?
Your Lordship, the students are affected. We are affected by the recent amendments in the Act, Your Lordship.
See, none of the Advocates Association or anybody has challenged this amendment. See, you are an NGO. What is your locus standi to challenge?
Your Lordship, the reason we have the locus standi, it evolves from the case, as the PIL is evolved from the case of SP Gupta.
No, you don't evolve your right from a case law. You say how you are an aggrieved person, how this amendment directly affects your rights.
Lordship, speaking from the organization's point, the organization represents not, as already previously stated, not only the students, but also the professionals and everyone and the institution who come under the legal fraternity. And Your Lordship, the reason the organization has the power to enforce this one comes from the case of Bandhuva Mukti Morcha versus Union of India, where it is clearly stated as a general standing that organizations can represent the aggrieved parties or aggrieved class or agreed class.
Are they denied access by this court?
No, Your Lordship.
Then how do you get the locus? That is the query.
Your Lordship, it is much better for a single party to represent all.
The advocates are elite group of members. They don't want your support, or they don't want somebody to challenge you, challenge the amendment. They themselves have not come forward to challenge.
Your Lordship, the SLSC is an advocate association, and therefore, there is no requirement for any direct injury to. Indeed, Your Lordship, as it is representing the entire advocates, this one, and the case of public union.
You are representing an advocates.
Not
You are an association
Your
of advocates.
They are representing the law students, institutions, and professionals.
Proceed.
Indeed, Your Lordship.
Because an advocate will not be aggrieved under this amendment as they are already enrolled.
As they are already enrolled. Apologies, Your Lordship. The council meant to say that it was the enrolled law graduates.
To be enrolled.
To be enrolled. Apologies, Your Lordship.
Proceed.
And whereas UGC, a regulatory authority body, has an interest in ensuring that the amendment which is affecting the legal education and adhere to the constitutional principles. And UGC has a stake in this one, as it is a legal injury, because the UGC, as Your Lordship, the UGC is also a party to the present case. Yes. And so the reason the UGC is a party, as there is a legal injury because of the violation of the statutory powers without a consultation of the mandate which by the AI.
That consultation process has been mandated under the Act.
Your Lordship, the consultation is being referred to in the Advocates Act.
Yes.
The
With
precise
the UGC. You mean to say that before creating any amendments, UGC has to be consulted?
Indeed, Your Lordship.
Where?
The same is being referred to in the Advocates Act, but the section is much obliged, Your Lordship. Your Lordship, and the current legal standing requires no NET and SET qualification for the association professors, hiring further both being the regulatory bodies and should function in coherence.
The issue.
No, Your Lordship, there's just one more point.
Why are you skipping over?
Indeed, Your Lordship.
First address that locus standi alone.
Indeed, Your Lordship. Your Lordship, the locus standi is already been addressed. The exceptions for a writ not to be, this one will be stated right now in the further arguments. It is humbly submitted that the maintainability of a writ petition for the enforcement of a fundamental right can be questioned only on the grounds of lapses, delays, acquiescence, drafting of the petition in an undignified manner, enforcement of private or contractual rights. And in the aforementioned case, none of these exceptions are this one, as it is filed in the time question of law are involved, fundamental rights are sought to be enforced. Your Lordship, therefore, the Honorable Supreme Court is competent to decide the legality of the circular under the Article 32. Your Lordship, if there is no further clarification.
Why are you bypassing the High Court and coming to Supreme Court straight away?
Your Lordship, the reason the Article 226 was not invoked in the present case is because in a case that is of L. Chandra versus Union of India, it has been clearly stated when faced with a fundamental rights violation, the petitioner can invoke Article 32 and Article 226 need not act as a bar to prevent the petition from invoking his right in the case of violation of fundamental rights. And also as it affects the people en masse, not only in a particular state but the entirety of the country, the petition has the right to invoke the jurisdiction of the Honorable Supreme Court under Article 32. Yes. Much obliged, Your Lordship. Your Lordship, the issue 2 states whether the amendments mandating all India bar examination clearance for enrolling as an advocate is valid. Your Lordship, it is humbly submitted that the Bar Council of India has the power to conduct the All Indian Bar Council examination, and the same has been confirmed and reiterated in the Bonify versus Union of India, 2023 S7 SCC 756. The same copy has been forwarded to the bench.
You mean to say that the Bar Council has power to conduct the examination?
Indeed, Your Lordship. They have the authority to conduct.
Then why do you challenge?
However, the current challenge is not for the authority, but it is for the mandate. It's for the mandate, the current mandatory form of the ASB examination, as it is been challenged on the grounds of the format, mechanism, and improper application. Your Lordship, there are.
What is that improper application?
Your Lordship.
Format.
Indeed, Your Lordship. The improper application refers to the as in the pre-amended act. It allowed the law graduates a 2-year leeway before they can enroll as an advocate, and this 2 years they could go and intern under
So
a
you
senior
mean to say
advocate.
that after practicing alone, they have to write the exam?
Indeed, Your Lordship, as they have the as by practicing in the courts, they have a practical this one, and not just the acumen which is just learned from the university.
So law degrees are waste.
The law degrees set the basic, the fundamentals for.
What is the need for the separate examination? Already the students are undergoing several examinations.
Indeed, Your Lordship.
What is the need for a separate examination? It's an open book examination.
Your Lordship, though it is an open book examination, 50% of the current, there is a 50% failure. And the counsel for the petitioner humbly submits that the further 2 limbs, the prongs will be dealt with the current issue. Your Lordship, the pre-amended act and allow the law graduates a period of 2 years after completing their law degrees, and this new the new amendment does not address the requirement of such a mandatory under the ASBE examination. Even after passing the rigorous examination, it is held by which is held by the universities, making them eligible to practice law. The current nature of the amendment disregards the right to profession of law graduate under Article 19(1)(g) of the Constitution.
See, if you underwent some rigorous test examinations by the university, then ultimately it will be easy for you to undergo another test.
Indeed, Your Lordship, but
So that will be the reason for testing that provision?
Your Lordship, the Bar Council of the Indian Bar Examination Clearance has to be given in a new format to test the competence, that is the practical scenario or the skills by the advocates. And this practical skills will only be seen in an advocate when they practice in the court and not only just study the law and come.
Is it not at the stage of a premature level that not a test has happened, only an amendment has come? That too in the Act and the rules. That is the main legislation and the subordinate legislation, it has come. How do you presuppose or presume a thing which is yet to happen to say that the test is of this level or that level?
Your Lordship, there is a legal injury which has been sufficed by the UGC and the...
Competence, you admit.
Indeed, Your Lordship.
Power to enact, you admit. ASBE is the authority to regulate legal profession, you admit. When the power is there, competence is admitted. You can't presume a thing which, a legal injury without its actual happening, except in a matter of anticipatory bail. How do you approach this court at this level?
Your Lordship, there has been a legal injury. When we see in the case of UGC, under the Rule 5C, which
UGC doesn't take a test. It's only a prescribing body granting degrees. Therefore, it is not an affected person.
Your Lordship, the UGC is an affected person, as in Rule 5C, it's clearly mentioned as the subjects, that is the curriculums, has only been restricted to LLB and BLLB as prescribed in the Amendment Act. Your Lordship, the Council seeks to invoke that the ASB is conducted in English language, whereas the advocates are well versed with the procedure in the vernacular language. And vernacular language is the most used in the lower courts. And the current form of ASB, if made mandatory, will evaluate the acumen of the law graduates and not the practical skills needed for a law graduate to be a qualitative law graduate. And to understand the legal procedure...
Counsel?
Indeed, Your Lordship.
Now that you are saying that it is in an English language and it has to be in the vernacular, is that anything in the proposition to that effect? Why are you widening the scope?
Your Lordship,
I think we have not seen such things. If it is there, you please highlight.
no, I beg to... I think the prop doesn't mention
You are
about the
thinking.
no, Your Lordship. The prop does not mention about the vernacular language.
Then why are you waiting the scope?
Your Lordship,
Address the issue alone.
Your Lordship, we are speaking about the form of the exam, not the authority of the BCI to invoke the exam. We require the...
So if the examination is going to be conducted in English language, you are agreeing?
Indeed, Your Lordship. Indeed, Your Lordship. And that's why we come in front of the court to invoke that examination can be like not only in English but vernacular languages. Lordship, as it is discriminatory for those who studied in a vernacular language and to write the knowledge of law in English, as the conversation can mislead and can prevent from conducting the true meaning. And not only
See, the amendment alone is broad. How the amendment is arbitrary or unconstitutional, that is alone to be tested here. You are not going to, you are not supposed to speak about the form of the exam which is going to be scheduled or which is proposed to be scheduled. You are only challenging the amendment. So how do you challenge how it is ultra virus?
Your Lordship, in the instant case, the authority is not been questioned. It is the form, as already reiterated in the previous state. If the form or if the mode of the form of the exam is not valid, the entire exam itself become invalid, as the main intention of the objective of conducting such an exam is...
Counsel, it's not a physical injury in a judicial review which is noted. It is the legal injury you have to point out. How is it contrary? The query is very specific. How is it ultra virus? Either the constitution or the statute or the delegated legislation being in excess of its powers. These are the legal injuries you can plead in a court and argue. Please explain how is it ultra virus?
Your Lordship, it is ultra virus as it goes against, it violates the Article 14 and Article 19(1)(g), which will be reiterated in the further argument.
14, how do you bring in?
Your Lordship, 14...
And 19 also, because 19(1)(g) you quoted. Then what is the impact and purport of 19(6)?
Indeed, Your Lordship. Your Lordship, the Council seeks permission to continue with the arguments, as the same will be reiterated in the further arguments. Much obliged, Your Lordship. Your Lordship, it is if the exam is made mandatory, it will affect the law graduates of economically weaker backgrounds and the backward classes, and also those classes whose medium of education is not in English. Further, it makes the objective of the conducting of the examination redundant, as the actual competence is not evaluated, only the acumen of the law is evaluated, and hence the current amendment.
So is it your case, if the fees is reduced, you will take the exam?
Your Lordship, it's not only the fees which is to be reduced. There should be as in the pre-amended act.
No, economic considerations is different when it comes to statutory interpretation.
Indeed.
Please, this query is specific. Is it your case, is the petitioner's case that if the fees is reduced, then are you willing to take the test?
Your Lordship, indeed, Your Lordship, but just reiterating, furthering the arguments, the reason economical weaker section was put in the arguments is that it is discriminatory for those people who come from such a background, as they are not able to go for the course as without the enrollment exam, and due to which they don't have a monetary.
Is there a right to free higher education in this country?
According to Article 21A, there is a right, right to education.
Right to education is different from right to free higher education.
Free higher, indeed.
Is it there in the Constitution?
Indeed, not free education, Your Lordship. It's not there in the Constitution.
Then where does your ground of economic criteria become a ground to attack a legislation?
Your Lordship, the reason the economical weaker section is being invoked is due to the reason that it violates Article 19(1)(g). As if there is an income barrier for the law graduates from this.
Counsel, if your logic is accepted, then in NEET, everybody will be eligible. Therefore, put your legal injury on the ground of, because we are on the specific question of maintainability. The other issue is on the ultra-virus. The query is very specific.
Indeed.
Make your submissions on how you attack it as ultra-virus.
Indeed, Your Lordship. So, Lordship, I would like to seek permission to further the arguments, as it will sort the clarification. Your Lordship, by analyzing the amendments of under Article 14, the twin test has been used, which is developed by the Justice S.R. Das in the state of West Bengal versus Anwar Ali Sarkar, 1952 SCR 284. the same copy has been forwarded to the bench. Your Lordship, in the present case, the criteria of intelligible differential and rational nexus was sought. Your Lordship, the intelligible differential refers to the clear and discernible basis that differentiates one group of people with another for the purpose of the legislation. And it is a criterion that justifies the classification of people. Your Lordship, for that, it involves two fundamental concepts. That is, the classification must satisfy two fundamental concepts. That is, the classification must be based upon the intelligible differentia, and there must be a rational relationship with the object of law, that is in the present case. And in the case of Subramaniam Swamy versus CBI, 2014 8 SCC 682, the same would be forwarded to the court. Your Lordship, the court, after discussing various judgments dealing with the principles of discrimination, ultimately held that if the classification defeats the purpose prima facie, it is invalidated. Your Lordship, the counsel for the petition would like to humbly state that if there does not exist an intelligible
Counsel,
differential.
we are conducting of an examination. I think you are addressing the second issue. I think, conducting of a bar examination.
Bar examination.
Whether the conducting of a bar examination is going to affect the constitution or ultra.
Your Lordship, conducting of the exam is not going to affect, but conducting of the exam immediately after the rigorous 5-year course, which the law graduates go through, is what we are contending, Your Lordship.
See, when it is conducted immediately, it is very much necessary, rather delaying the examination by 2 years or 3 years.
Your Lordship, it is required to delay the exam not because of the...
See, it's only a qualifying exam. So if it is sooner the better.
Lordship, if it is sooner, it will only test the law graduates on the basis of acumen of the law, not the practical questions of law. And
Counsel, please see your legal issue number 2 for a minute and then make submission. If you want, we will remind you whether the amendment mandating all India bar examination clearance for enrolling as an advocate is valid is the issue raised. The question here is on the mandating, because you are only addressing 1 and 2, 2 and 3 and 4 will be your co-counsel. So on issue number 2, mandating is the term which you have to stick to. Explain us how it is.
Lordship, not only mandating, but also the enrolling of an advocate. Lordship, the mandating of an exam, as already reiterated, the Bar Council does have the authority to mandate the exam. But what over here we are challenging is the form and the format of which the exam is being conducted. As the immediate conduction of such an examination would be discriminatory to a lot of classes, and the further is being said in the following arguments. The counsel for, there is no intelligible differentia for the pre-2010 and the post-2010 advocates. As already stated, as already been confirmed from the case of Anwar Ali Sarkar, Your Lordship, the 2000, and it will be discriminatory for those advocates who are going to enroll after 2024, as they have to write their exam immediately after their examination. Your Lordship, the next criteria is a rational nexus. Your Lordship, the rational nexus creates an, according to this, if there is an arbitrary artificial distinction, if it is created, it is discriminatory to a certain class of people.
Counsel, be clear.
Indeed, Your Lordship. Much obliged, Your Lordship. Your Lordship, the next criterion which has been established, which has been sought to, is the rational nexus. Rational nexus states that if there is an arbitrary artificial distinction, if it is created...
Your point must be specific. We already said be clear, because rational nexus, the unreasonableness, all are concepts.
Indeed, Your Lordship.
Generally, we don't want an argument at the final level.
Indeed.
We want a counsel's argument specifically addressing there are 4 issues only in the competition. You have taken 1 and 2.
Indeed, Your
On that, please go in depth.
Indeed, Your Lordship.
Nothing more, nothing less.
Indeed, Your Lordship. So, Lordship, it's already been established that the current exam is violative of Article 14, and the same has been sought out through the case. Indeed, Your Lordship, Article 14.
Conducting of an examination is violative of Article 14.
Not conducting of the examination, Your Lordship.
Just now you said.
Pardon, Your Lordship, not conducting the examination, but the form of the conduction of the examination and the classification which is being done. That is the 2010, pre-2010 and the post-2010 advocates. And also it is violative or it is discriminatory for those advocates who are going to write the exam in the future. That is the post-2024.
Counsel, that goes to issue number 3 and 4. We are again reiterating, be clear. Your position here is to explain your locus and admissibility of the petition. The second relating the amendment being mandating for clearance of examination for enrollment is on the statutory competence and the invalidity in terms of legal proposition, which we want you to be explaining.
Indeed, Your Lordship.
You are jumping into the third issue which your co-counsel is going to argue. You restricted 1 and 2 on which, and you explain your role there in legal principles.
Indeed.
Understood? Indeed. Now, in fact, to put it more straight to you, the second issue is relating to ultra-virus question.
Indeed.
Answer the ultra-virus question with your legal submissions.
Indeed, Your Lordship. Your Lordship, the reason it is being invoked for ultra-virus is because the current exam, we are not as already reiterated, we are not conducting the exam based on the authority, but on the form. As the two main arguments, that is the pre-amendment allowed 2 years, while the post-amendment act does not allow or does not address these 2 years.
You have not understood. See, you are challenging the All India Bar examination itself. The amendment bringing in All India examination itself is challenged by you.
Indeed, Your Lordship.
That is the second issue. So how this is affecting the rights of a student or an advocate, that you have to point out.
Indeed, Your Lordship.
See, conducting that examination, how it is detrimental to the interest of a student or a person.
Indeed, Your Lordship. So, Your Lordship, it is detrimental to the law students and especially those law graduates after post-2010, as they have to write their exam immediately after the rigorous 5 years. And as we sort out that we are not against the mandating of the exam, but the form of the mandate. And already as stated, the pre-amendment allowed and gave a leeway of 2 years before the enrolling. And the post-amendment does not speak or does not address the same. Your Lordship, if the same is not addressed and the 2 years is not given to the law graduates, it is discriminatory to them. And especially to those advocates who are going to write their enrollment exam after post-2024. That is the main like the reason to go for the ultra-virus of the present mandate. Yes, sir. Your Lordship, the next is the examination violative of the fundamental rights under Article 19(1)(g). Your Lordship, the current exam is violative of Article 19(1)(g) as a restriction does not serve any public interest. Your Lordship, as it restricts the entry of an advocate.
See, 19(1)(g) has also given reasonable restrictions.
Indeed, Your Lordship.
It is not blanket.
Your Lordship, though reasonable restriction has been given, and it cannot put a bar or it cannot put a stoppage to a person from enforcing or to practice his profession.
No, he has to qualify himself.
Indeed,
it is not a, what to say, it is not a bar or a stoppage.
Your Lordship, it's a preventive bar.
It is not a preventive bar, mister. It is only a qualifying exam. It only qualifies you to enroll.
Your Lordship, though it does not.
Counsel, please note, enrollment, getting educated and getting a degree is not automatic enrollment in law profession. Therefore, there is a gap between becoming a law graduate and becoming an advocate.
Indeed, Your Lordship.
In this, the power to make you enter the law education is with the Bar Council. And further to make you enter into the law profession is also with the Bar Council. It is there in between that bridge area the test comes in based on the Supreme Court dictum. And that is how the amendment has come into place. So, specifically content as to how this examination in between a law graduate and a lawyer becoming that bridge area, this entry toll or entry test is unreasonable or whatever. And here the second issue which you are restricted to is only on the power and the ultra-virus. Because your co-counsel will argue 3 and 4. So don't confuse and club 3 and 4 in issue number 2. We want the 4 questions framed in the MOOT each are having distinct sphere of operation.
Indeed, Your Lordship.
That is what we want you in the finals to say. You have to restrict yourself to circle number 2.
Indeed, Your Lordship. Your Lordship, the objective of the examination is unclear, and the purpose to ensure that the competence of the legal practitioner and then the application of only to law graduates from 2024. Your Lordship, the council seeks on the debate of acumen versus the practical knowledge of the law graduate. Lordship, the acumen of the law is not sufficient enough to be a qualitative law graduate. For a qualitative law graduate, you need to know the basic, not only the basic, but also the practical scenario on how you can go about reiterating the same in the code. And the ASB does not, and the examination does not provide for why does not provide for the practical necessities, Your Lordship.
I think your time is over.
Indeed, Your
You can
Lordship.
give space to the co-counsel.
Indeed, Your Lordship.
Your Lordship, the co-counsel B shall be dealing with issue number 3 and issue number 4. Due to paucity of time, the co-counsel would like to club both these issues. Your Lordship, issue number 3 deals with whether the amendments to the Advocates Act 1961 are arbitrary, and issue number 4 deals with whether the amendments made by the BCS to the rules are arbitrary or not.
They can't be clubbed together because one is on the main statute, another is under the delegate legislation. They operate in different spheres. So you go with 3 first and then come to 4 because both cannot be attacked simultaneously and as you want together. The issues are framed in this competition so because they have a specific meaning and relevance. Address 3 with your capacity, address 4 separately.
Indeed, Your Lordship. Your Lordship, I would like to employ the reasonability test in this particular issue. Your Lordship, the current amended section 2A of the Act prescribes that there is a mandatory nature of ASBE in the definition of the advocate. To be an advocate, they have to pass the ASB examination. Your Lordship, however, it clears a arbitrary classification as mandatoriness of this ASB is being put forth without the 2-year gap that was previously instituted, Your Lordship. And such a closure of such 2-year gap is actually in detriment to the law graduates, Your Lordship. Your Lordship, from the reference document that has been produced, pages 3 to 11, it has been clearly stated in the interest strengthening of the legal institutions case that the current ASB in its format as well as in its induction does not address the main objective of the ASB, Your Lordship. Your Lordship, when the ASB was instituted in 2010, the objective was to increase the standard of legal landscape, Your Lordship, by increasing, by ensuring that only valid and competent lawyers are to be enrolled in the Bar Council, Your Lordship. And the current ASB in its format does not provide any metrics to evaluate the same, Your Lordship.
You are arguing on issue number 3 with regard to arbitrariness.
Indeed, Your Lordship.
Legally make your submission with regard to the arbitrariness alone.
Indeed, Your Lordship.
Already your co-counsel has submitted with regard to the examination and other things.
Indeed, Your Lordship.
We have noted down. Be specific on arbitrariness alone.
Indeed, Your Lordship. Your Lordship, while making this amendment, the Parliament has not given any reasonable explanation for the same to decrease the 2-year period, and which has been detriment to the post-2024 law graduates, Your Lordship. And such a classification made without any guidelines or without any reasonable explanation can be called as an artificial distinction that has been made by the Parliament, Your Lordship, and which is one of the fundamental factors to invoke the reasonability test, Your Lordship. Furthermore, the rational nexus sought to be achieved is to increase the competency of the lawyers as well as the advocates that are going to be enrolled, Your Lordship. However, in the current case, the ASB does not put forth any metrics, and as well as it's only tests the acumen of the law graduate, Your Lordship. Acumen basically means if provided equal opportunities, everyone can be dealt in equally. Your Lordship, in the current case, the ASB is conducted in English language as put forth by my co-counsel, Your Lordship, and anyone who's been trained in vernacular language cannot be tested of their competency with such an examination, Your Lordship. If it is to test the competency, it should actually test the practical skills of the law graduate, Your Lordship, which has not been put forth in the ASB examination, Your Lordship. So the rational nexus sought, if it was to improve the legal landscape and its competency, then the ASB examination is not a valid ground, Your Lordship.
Counsel, if your contention is accepted, do you mean to say in every court that all multiple languages based on the litigants, the courts must, and will it not be a burden on the judiciary to then take, one will say in one vernacular language of the state, another will say in English, it binds many, though of course language is a mode of communication, it also depends on the convenience of the entire process. It should never be looked upon from your candidate process because it is uniforming throughout the country one stature, where maximum convenience is what the principle in legislation. There is no principle in any legislation that it is 10% convenience and confirmation. Correct? Doctrine of majority is the fundamental element in any democracy. even in democracy, leave alone being a governance under other procedures, like complete authoritarianism. Democracy always admits a minority sufferance. Majority happiness is democracy. Therefore, can you take in such a circumstance the linguistic barrier is a difficulty in terms of Article 14? Please explain.
Your Lordship, the linguistic barrier is one of the factors, Your Lordship. Your Lordship, the main contention here is that how ASB fails to evaluate the law graduate, Your Lordship. It's not only the linguistic barrier, but also all the things coupled with it, Your Lordship. If you take it as an individual bracket, it would only lead to the validity of the law, Your Lordship. However, if combined together, the whole provision reads down as so that it discriminates certain class of the society, Your Lordship. Even if the doctrine of majority is practiced, it cannot impose unreasonable restrictions or unreasonable violation of fundamental
Is not the country under the Commonwealth law and English the factor even in your education under the ASB rules which guide your, because your graduation, is it your case it's in vernacular, all vernacular languages, the graduation is done under the ASB rules? Even in the MOOT problem it is not there. And you follow Commonwealth law country and that's how we come in. Once Commonwealth comes in, English is automatically brought into you. How do you still say it is violated of Article 14?
Your Lordship, by employing only the language of English, they are actually discriminating the law graduates who have done their language, Your Lordship, and not English language, Your Lordship. And hence, in that case, if a law graduate is well versed with the vernacular language and well versed with the procedures of that state or of that particular jurisdiction, then it should be granted in his favor that he should be evaluated in that basis.
Your point is taken. Linguistic barrier is one of the arbiters.
Indeed.
What next?
Your Lordship, the ASB does not actually fulfill the rational nexus part of the amendment, Your Lordship. So, while imposing such a rational nexus, they should actually consider whether they're actually evaluating the practicality of the examination or the practical knowledge of the law graduate. However, under ASB, there is no provision to.
What do you mean by practical knowledge?
Your Lordship, practical knowledge there is no clear definition for the same. However, the council would like to say that practical knowledge includes the way of presentation, how the court proceedings are done. Your Lordship, in an university, they only reach the theoretical knowledge, but not the practical knowledge that has been.
You are not going for internship and other things. What is the reason for sending the law students for internship and other things?
Your Lordship, even though we are going for internship, it does not mean that we are getting substantial practical knowledge. As such, we are practicing under a senior advocate, Your Lordship.
Under the legal education curriculum which you claim to have graduated counsel,
Indeed, Your Lordship.
the parties whom you seek to represent, it is part of their curriculum to attend court, take guidance under senior, and every semester they are supposed to have an internship, and also court watching and court noting is part of your legal curriculum. Therefore, practical knowledge is not acquired means, does it mean the curriculum fixed is wrong or the student's incapability to attend to it?
Your Lordship, the petitioner only contends that.
And for that ground, how will a statute be attacked as arbitrary?
Your Lordship, the petitioner only contends that the practical knowledge in the previous statute it was given that 2 years time period. 2 years time period was granted for them to gain the practical knowledge, Your Lordship. However, in the current amendment, the 2 years period is being removed, Your Lordship, and that's a critical and valuable time for which a law graduate.
And is that not an advantage? After 5 years of degree, you had to wait for 2 years. Now, if it becomes less than 2 years, is it not an advantage to the graduate?
Your Lordship, provincially they could be enrolled, Your Lordship. The circular dated 15/9/2024 issued by the Bar Council to the state high courts says that provincially they can be law graduates can be enrolled without even clearing the AABE, and after 2 years if they clear the AABE they should be reinstated, and if they do not clear the AABE within those 2 years they should be removed from the roll, Your Lordship. And in the current case it has not been done in the similar situation, Your Lordship. So the pre-2024 law graduates have the privilege of going to courts for 2 years, then attending the ASB.
See, it is going to be for the benefit of the profession, advocates who are going to take the profession.
Indeed, Your Lordship.
If you give 2 years time, then everybody will take their own time to come and write the exams.
And as you seem to be afraid of your level of qualification, probably it creates a doubt in the bench that are really the fresh graduates so afraid of taking one exam, that too immediately after having taken exam, is their memory too short to require another waiting time or a gestation period to further acquire knowledge and take the practical test?
Your Lordship, I would like If considered individually of all the contentions, it will prove that the amendment is constitutionally valid. However, if taken the combined effect of all these factors, it will show that ASB is actually does not regulate the proper standards for evaluation of a law graduate, your lordships. And in that contention, ASB is actually failing to achieve the objective that was sought for its institution, your lordship. And in that contention, we say that ASB's mandatory nature as instituted in the current amendment is arbitrary, your lordship. Moving forward.
See, when bench is not with you, so you can come out with your best point because of time is running. So when judges are not agreeing with these points, so to some other point, and immediately try to convince the bench.
Your lordship. Your lordship, coming to issue 4. Issue 4, the amendments made are apparently for the uniform standardization of the legal landscape. However, there has been no consultation with the UGC, your lordship. BCS is actually supposed to consult UGC, then make these changes, your lordship. And from the case.
Consultation process with UGC, where it is mandatory.
Indeed, your lordship. State of Tamil Nadu versus SV Pradeep, Manu SC 2028 will be copied.
All the stakeholders, colleges have been consulted.
Indeed, your lordship.
Why come the university, UGC, and has to be consulted?
Your lordship, UGC is actually the premier regulatory authority regarding education, your lordship, in the higher education.
Not having any authority to regulate the.
Your lordship, they have overlapping authorities. However, it is
overlapping authority
regarding the legal education, your lordship, not regarding everything else. However, since it is the regulatory authority for higher education in the country, it should have BCS is mandated to seek the advice of UGC. That's the only reason the UGC is
Counsel,
coming.
in issue number 4,
Indeed, your lordship.
it's violating or exceeding constitutional limits and principle in making the uniform standards.
Indeed, your lordship.
Now, Bar Council does not take away your degree as such.
Indeed, your lordship.
Your degree given by the UGC is intact, pursuant to university grants, and taken under law courts is intact. It is at the enrollment stage only the uniform standards are introduced in this present amendment. If that be so, how do you say it is exceeding the powers, and what is the latent as well as patent violation which you want to point out?
Your lordship, Rule 27 of the issue that you are addressing regarding the arbitrary and violative or constitutional principles exceeding the constitutional principles. Actually, in the case that has been provided, State of Tamil Nadu versus SV Bardit, the court has clearly mentioned that 1 year LLM is equal to 2 year LLM, your lordship, and the regulations can only supplement but not supplant the degree granted by the universities, your lordship. And in the current situation, without the UGC's guidelines, which is a higher authority for hiring of teachers as well as legal graduates, where UGC has clearly mentioned that only assistant professors require the qualification of net and SAT qualification, your lordship. And it has been clearly provided in the UGC guidelines, your lordship. Associate professors do not require net and SAT qualifications according to UGC's 2025 rules, your lordship. Hence, the current amendment is actually without consultation, is circumventing the process and trying to establish the same, your lordship. Furthermore, the objective that was stated by the BCS while bringing about this delegated legislation amendment is that there is a requirement of more legal professionals to be in the education practice. State the same. Under section 24(1)(f), the current amendment states that rupees 0 to rupees 20,000 can be charged under the current amendment for an enrollment fee, your lordship. However, from the case of Gaurav Kumar versus Union of India, where it was stated that if section 24(1)(f) prescribes it as 600 rupees, it can be established 600 rupees, your lordship. Even after calculating the cost inflation index and the average income of a Indian citizen, it is extremely exceeding the same, your lordship, and taking away substantial part of their income, your lordship. Whereas without clearing the ASB, they cannot enter the legal profession and gain their right to income, and the enrollment fee being a bar to the same is actually discriminating them from the legal profession, your lordship.
Your economic criteria is taken, then how do you expect these regulatory bodies to function, because they don't receive any grants? they receive funds only through these enrollments and other activities, then how can they function in not only framing the law, regulating it, and their existence? They have staff to feed. From where they will get the income otherwise?
Your Lordship, when a term is named as fee, it should be a quid pro quo relation, Your Lordship.
Come on, you're going to get an income as according to you, your 19(1)G is enabled by such an act. It's a one-time payment.
But
Whereas in Income Tax Act, it's every year payment. So in a cess and tax, it's totally different. You cannot ask this. But for administering, then who will bear the administration cost?
Your Lordship, while considering, it has been taken to notice, but while considering it as a fee and quid pro quo reaction,
It's not a sovereign function where the state has the responsibility. It's a statutory function. When it's a statutory function, fixing a fee is permissible, especially for the existence of the statutory body.
Your Lordship,
So it is also not a fixed amount. It has a variance which will depend on the circumstances. Therefore, how do you presume that they have not considered at all and attack it as being exceeding constitutional limits? Precisely.
Your Lordship, while considering the amount that has been fixed, SC/ST category has been fixed around 13,000 rupees, Your Lordship, which is 2/3 of the.
Therefore, is there not an intelligible differential in it?
Your Lordship,
They have not fixed 20 to all. They have made 13,000 to one category. They have made 20 maximum from particular. Therefore, there is intelligible differential. Then is your argument not self-defeating?
Your Lordship, previously it was 600 rupees, Your Lordship, and the current increase shows an increase of 3,333%, Your Lordship.
The Advocate Act was of 1961.
Indeed, Your Lordship.
Amendment is of the year 2024. 60 years have gone behind. Forward we have come. Do you mean to say it will remain still stagnant? Like bullion rates, have they changed or not? Market rates have not changed or not? Therefore, 66 decades later only this amendment of increasing the fees comes. How do you say still it is bad?
Your Lordship, it is not the mathematical exactitude of the number of years, but the cost inflation index that has to be calculated, Your Lordship. The change has only been 180%, Your Lordship, which does not equate with the 3,333% increase in the fees.
No,
Your Lordship.
even the per capita income has raised. That is the finding.
Indeed, yes, Your Lordship. However, in the current case, the increase is unreasonable, Your Lordship, since it takes a substantial portion of their income in the first instance, Your Lordship. Like that's a monthly income of an average citizen in this nation, Your Lordship. And if that is to be submitted as the enrollment fee, most of the legal professions will be discouraged from doing the same, Your Lordship, and they might opt out for other professions, Your Lordship.
It again defeats your argument that they are denied of entry to the thing. That is, profession is one aspect. That's what law graduation, your UGC is not affected. Law enrollment, this ASD alone can do it. Where they are doing it, fixation also, there is intelligible differential. Then how do you still substantiate your arguments on the 3 and 4 issues?
Your Lordship, this is not concerned with the UGC. However, this is concerned with the amendment made by the Parliament, Your Lordship, and which is directly affecting the legal professionals or law graduates who are yet to be enrolled to the Bar Council, Your Lordship. And in the current scenario, if such a restriction or artificial barrier is placed in front of them without allowing them to even enroll in the bar and gain income, how can a law graduate reasonably expected to pay the higher amount without even having any any income in the first instance, Your Lordship? This is actually creating a barrier in the enrollment phase itself, Your Lordship.
Economic consideration is not taken even in constitutional reservation. Then how do you say a statutory action is bad?
Pardon, Your Lordship.
Article 16(4) deals with only socially and educationally backward. Economic consideration is now only recently this below poverty category has come. Therefore, how does it affect the constitutionality of a provision on this ground?
Your Lordship, the constitutionality of this provision is under question because of the arbitrary increase and without any guidelines, the percentage increase of 3,000%, Your Lordship. And such arbitrary increase without any guidelines or any explanation does not amount to constitutionality, Your Lordship.
Also, you can summarize your argument.
Indeed, Your Lordship. Your Lordship, the Council would like to proceed forward with the prayer. Wherefore, in the light of the issues raised, arguments advanced and the authorities cited, it is most humbly and respectfully prayed in front of the Honorable Supreme Court of India that it may declare the impugned amendments as invalid, upheld the locus standi of the petitioners, it may declare the impugned amendments made by the BCS to the rules as invalid, and further pass any other order which it deems fit in good conscience, equity and public interest.
Greetings, bench. May it please this honorable court, this is counsel appearing on behalf of the respondent. The counsel seeks permission to address the bench collectively as your lordship. Much obliged, your lordship. The counsel seeks permission to summarize the facts and issues of a present case. Much obliged, your lordship. Your lordship, the first two issues will be held by me and my co-counsel will be handling with the rest of the issues. Much obliged, your lordship. Your lordship, the very first issue is that whether the petition is admissible. The counsel for the respondent humbly submits that the petition is not admissible, your lordship. The petition filed by the first petitioner, that is Indian Legal Service Center, under Article 32, your lordship. Article 32 can be invoked only when there is a violation of fundamental rights, your lordship. But here, the amendments made by the respondent is not violative of any fundamental rights. As petitioners stated, they have stated that there is a violation of Article 14, 19(1)(g) and 21, and by the following arguments, I will be defending it, your lordship. Your lordship, first of all, Article 14, your lordship. Article 14 states the principle of equality. Principle of equality means that every law must have a universal application. That is, that all persons who are of same circumstances and...
Counsel, you mean to say that the associations cannot maintain a writ petition?
Indeed, your lordship, they can't file it under Article 32 since there is no infringement of fundamental right, your lordship. Indeed.
Under 32, they cannot file.
They can't file under Article 32.
Cited some judgments also.
Your lordship, I'll be defending it in the further arguments, your lordship. Much obliged, your lordship. Your lordship, here the amendments made to all the law graduates who is of same nature and circumstances, your lordship. Your lordship, Article 14 forbids classification, your lordship, but it does not forbid the classification that is of reasonable and which has a reasonable classification, your lordship, to the object of it. Your lordship, the classification made here is between the people who are enrolled and non-enrolled, your lordship. Your lordship, hence the classification is considered admissible, your lordship. The counsel seeks permission to submit the compendium, your lordship. Much obliged, your lordship. Your lordship, the counsel cites that in the case of Transport and Dock Workers Union and others versus Mumbai Port Trust and another, which is there in page number 194, your lordship, and in 11th line, it had stated that the classification made on reasonable basis, then it can't be considered as a violation of Article 14, your lordship. Here we have made amendment under a reasonable classification between the people who are enrolled and non-enrolled, and this can't be considered as an infringement of Article 14, your lordship. And as my learned counsel argued that there is a violation of Article 19, your lordship, there is a Article 19(1)(g), which states that the state can make law in the interest of general public, your lordship. Here, the interest of general public, as it is mentioned in the MOOT proposition of page number 2, your lordship, in para 8, they have mentioned that there is a 30% of lawyers were fake, your lordship. Your lordship, the interest of general public here in the sense is to eliminate fake lawyers, your lordship. The amendment here made to eliminate the fake lawyers, which increases the efficiency and efficacy of legal profession, your lordship. Your lordship, in Article 19, Clause 6, Subclause 1, which states that the professional...
Just a query. You say to remove fake lawyers of 30%.
Indeed, your lordship.
How do you say by only testing the future candidates you will be removing? Then is it not a case that fake lawyers have already entered your allowing, and will it not then be hit by, though it's a negative equality concept, then are you not making the, then you should have made the test uniformly applicable to all. You should not have made it prospective.
Indeed, Your Lordship, in the MOOT proposition.
This is your object. That's your submission, counsel.
Indeed, Your Lordship. Your Lordship, in page number 3 of MOOT proposition, they have explicitly given that BCS passed this to limit the number of NOCs, Your Lordship, that to be granted to new law colleges. However, more than 200 NOCs were granted, irrespective of the resolution given by the BCS, Your Lordship. Here they are very much correct in their side, Your Lordship. Your Lordship, Article 19, Clause 6, Subclause 1 states that the professional or technical qualification are necessary for practicing any profession, Your Lordship. Here, the amended section 2A, which is given in MOOT proposition, page 4, Your Lordship, they have stated that section 2A states that the completion certificate is mandatory to the completion certificate of ASB, that is All India Bar Examination, is mandatory for enrolling as an advocate. That states that it is in under Article 19, Clause 6, Subclause 1, it is considered as the technical qualification, Your Lordship, professional qualification to practice the law, Your Lordship. Your Lordship, moving on to the third contention which petitioners raised, that it is a violative of Article 21, Your Lordship. Your Lordship, Article 21 states that no person shall be deprived of his life or personal liberty except according to procedures established by law, Your Lordship. Your Lordship, the right itself impliedly states that no authority can accuse of violation of Article 21 if there is a procedure established by law, Your Lordship. As quoted in the case of Maneka Gandhi versus Union of India, they have stated that the procedures established by law must be just, fair and reasonable, Your Lordship. Here the amendments made by the respondent are fair enough and reasonable, Your Lordship. Your Lordship, moving on to the petition that is filed by the second petitioner, that is University Grant Commission, that the case challenging recognition pattern, degree standards and eligibility criteria, Your Lordship. Your Lordship, first of all, the BCS had exercised their own powers, Your Lordship. Your Lordship, the council seeks permission to submit the BCS rules, Your Lordship.
Here, just a query.
Indeed, Your Lordship.
You noted the petitioner's arguments on this issue.
Indeed, Your Lordship.
Now, you say it has a rational nexus. The objects ought to be achieved is to weed out fake lawyers, and you want to see that quality doesn't suffer. We quite see that. But then, the economic criteria which they are attacking, how do you answer that? Because does it not affect that? Therefore, a citizen born in this country, because of their poverty, should they be deprived of their ambitions to live a full life in this country as a citizen by becoming a professional? Because they have graduated. They have become law graduates, but they have to become a lawyer. In that process, how can you, the statutory body, deny an individual citizen the right to live? And how do you say that that does not offend 21 of the individual?
Indeed, Your Lordship. The council, there is a reasonable inflation, Your Lordship. As we see that the Advocates Act is enacted on 1961, and here the amendment is made on 2024. Your Lordship, in MOOT proposition of page number 6, the first para, it has given that there is a cost inflation index, Your Lordship. They have explicitly mentioned here, since there is an evaluation of years, it can be increased, the respondent has a power to increase since there is an inflation.
Their argument is that what is the need for the procedural examination? After undergoing 5 years, they are studying. After that, why such a procedural examination? That's what they are arguing.
Indeed, Your Lordship, it is a kind of procedural examination which standardizes the legal profession, Your Lordship.
What is the need? What is the need?
Indeed, Your Lordship, it is a kind of assessing, Your Lordship, the council...
How come you assess an advocate by mere one examination? How come?
Your Lordship, even in many developed countries, as in the case of BCI versus Bonifoy, which is in the compendium of page number 28, and 7A, which states that the BCS, bar examination is conducted as a precondition in many of the wealth nations, Your Lordship. Even in the developed nations like US,
So
they conduct...
we have to follow the other international standards, we have to follow that. That's what you are arguing now.
Indeed not, Your Lordship. It is not of that sort. Since the developed...
Under 32 you are arguing.
Indeed, Your Lordship.
Don't cite it something, there are the international standards they are conducting. We have to follow. You cannot compel us to follow that.
Indeed not, Your Lordship. It is explicitly given in the judgment of BCI versus Bonifoy, which is there in the compendium of page number 28 and 7A, Your Lordship.
What it says? We have to follow the international standards. Huh?
It's not of that sort, Your Lordship, but a bar examination is a condition for admission to the a condition to the bar in most of the...
What is the need? Already there's every year they are undergoing several examinations.
Indeed, Your
What is
Lordship.
the need?
Your
In a
Lordship.
single examination, whether you are going to qualify the advocates to the next level?
Your Lordship, it is a kind of assessment where we conduct to the law graduates to even make them more efficient.
They have not at all entered the bar. After finishing the course, they are going to write this examination. How come you are going to evaluate this thing?
There is any other exam is there in India, India regarding that, other professions, there is any entrance examination is there?
Indeed not, Your Lordship, but to eradicate this 30% of increasement of fake lawyers, in order to eradicate this, the respondent have
Who has
made...
given that certificate, 30% certificate? Without certificate, fake lawyers, or with certificate? You only provided certificate. Why you have not checked with?
Your
You
Lordship,
are supposed to check, and you have to filter them in the very earliest stage. You have to filter it. But you are giving certificate. You yourself claiming that 30% people are fake. Then it has no logic.
indeed not, Your Lordship. There is an increasement of fake lawyers, Your Lordship. Only to eradicate this, we have stepped out by mandating this examination, even to enroll as an advocate, Your Lordship.
Counsel.
We have, we got one kind of pro forma. We is filled up for each and every advocate. Through that, they have verified it now. Almost it is under the verification. Now, what is the necessity for exam is conducting only for filtering the fake lawyers? Why?
It is complete to improve the standards of legal profession, Your Lordship, which eradicates the fake
Counsel,
lawyers.
Are you really want to improve the standard of the advocate, or you want to eradicate the fake lawyers? Be specific.
Both specifically we speaks about, Your Lordship.
By conducting an examination, how come you filter the fake advocates?
Your Lordship, who just get failed by the examination, or even in the examination process, there is many verifications like police verifications where we can find out whether
Already you are having so many procedures.
only by the conduction of examination all the procedures has been happening, Your Lordship. Indeed, Your Lordship.
Fake lawyer passed bar exam. Whether all fake lawyers nowadays we are seeing many people they are passing fake lawyers. That means fake lawyer passed exam, then he will become a genuine one.
Your Lordship, once he is eligible to meet the passment level, he is considered as an efficient lawyer, efficient advocate, Your Lordship.
Counsel, what is the definition of fake lawyers?
Your Lordship, who didn't get a proper COP, that is certification of practice, Your Lordship.
Anyhow, you are going to filter it because you have several checks and balances even before enrollment. So once you find out that a person is impersonating or something, then his certificates are not having credentials, you are not going to permit him to enroll. Why again you want another bar exam? Thereby you want to undermine the graduation degree.
Just to improve the standards of legal profession, Your Lordship.
No, in what way?
Examinations conducted by the colleges are not up to the standard. Only the final examination conducted by the AIB alone have such a standard.
It can't be considered in that way, Your Lordship, though they have studied for 5 years, and after they need to meet this kind of examination to completely check their overall idea of the legal knowledge which they have attained for this past 5 or 3 years where they have been studying in their college, Your Lordship. Your Lordship.
One more question to you regarding the maintainability of the writ petition. You are telling
Indeed,
that they
Your
are not supposed to come and knock the doors of this court under Article 32.
Indeed, Your
Are
Lordship.
we without any jurisdiction to entertain such writ petitions?
Your Lordship, Pardon, Your Lordship.
See, you say the petitions filed under Article 32 is not maintainable.
Indeed,
And
Your
are
Lordship.
we debarred from entertaining such petitions?
Indeed not, Your Lordship. Since there is no violation of fundamental right, they can't be
See,
invoked.
simply because there is no violation of fundamental rights, are we not entitled to deal with such an issue?
Your Lordship, even High Court has the jurisdiction where they can where they can file against under Article.
Then what is your answer for Article 139?
Your Lordship, they have merged the
See,
matter.
Article 139 says, other than the grounds specified in Article 32, the Supreme Court has got jurisdiction under Article 139 to entertain all matters which are not defined under Article 32.
Your Lordship, Article 39, which simply states about the merging of cases, Your Lordship.
No, not merging of cases. That is 139A. That is transfer of cases.
Pardon, Your Lordship. So apologies, Your Lordship.
See, counsel, practicing as an advocate is a statutory right or fundamental right?
Fundamental right, Your Lordship, under Section 30 of Advocates Act 1961, Your Lordship.
It is not only statutory right, but also a fundamental right.
Indeed, Your Lordship.
When you are imposing or certain amendments with regard to the profession, entering the profession,
Indeed, Your
not
Lordship.
violation of fundamental rights of a person.
Indeed not, Your Lordship. The council would like to cite a case where the court had held that in the case of Dr. Haniraj L. Chulani versus Bar Council of Maharashtra and Goa, which is there in the compendium of page number 48, in point F3 states that.
Citation. Counsel, you owe a duty not only to the court but also to the other side. Therefore, when you
obliged.
cite a citation, you must give at least the citation so
Much
that the other side
obliged, Your
knows.
Lordship. Apologies,
This is
Your
one of the
Lordship.
court practice matters.
Much obliged, Your Lordship. Dr. Haniraj L. Chulani versus Bar Council of Maharashtra and Goa on at 1996 AIR 1708, Your Lordship. It is there in the page number of 48 F3, where the court had held that the BCI has the power to mandate the filtering of students, Your Lordship, at the entry point of the profession, Your Lordship. The court also had held that, for example, by providing the examination by enrollment as an advocate, Your Lordship. Your Lordship, therefore, this states that the BCS has the right to decide and amend at what stage they need to conduct the examination, Your Lordship. Your Lordship, continuing with my arguments of first issue. Your Lordship, in the rule of 18 clause 1 of BCI rules, they have said that we have the recognition, we have the power to give recognitions, Your Lordship, and the amendments made are to promote the legal education and standards, Your Lordship, which is there in section 7(1) subclause H of Advocates Act and section 49(1) subclause D of Advocates Act, Your Lordship. Your Lordship, it is explicitly given in the fact that in page number 4 in para first, the BCS also noted that many remotely situated law colleges were not receiving assistance from UGC, Your Lordship. Here, the primary duty of UGC is to provide affiliations to university, which is under their control, Your Lordship. But UGC failed in their primary duty, to perform, Your Lordship, and also restricts the body like BCS who exercise their own powers, Your Lordship. Your Lordship, therefore, the Counsel for Respondent humbly submits that the petition is not admissible, Your Lordship. Much obliged, Your Lordship. Moving on to the second issue, that is whether the amendment mandating All India Bar examination clearance is valid, Your Lordship. Your Lordship, that amendment is considered valid. As we all know, the government has the ability to make law that is which in a considering on the basis of functioning of a democratic society.
Counsel, existence of power in an authority is never disputed, especially when it's statutory or constitutional.
Indeed, Your
It
Lordship.
is the exercise which comes in for question in courts.
Indeed, Your Lordship.
So, your existence, they have conceded. They say they can mandate. The petitioner has argued. Now you have to say specifically
Indeed,
how
Your
the mandate done, is it validly done? That is what their query is.
Indeed,
So
Your Lordship.
answer that.
Indeed, Your Lordship. Your Lordship, as I have mentioned before, in that case of Dr. Haniraj L. Chulani, the court had held that BCA has the power to amend and to take decision at what stage the exam should be conducted, Your Lordship. To further to it, in the case of Archana Girish Subnis versus Bar Council of India, on AIR 2015 SC 913, where their court had held that any law graduates must fulfill all the requirements and conditions prescribed by the BCS. Your Lordship, it has given in the compendium of page number 13 and point 31, Your Lordship. Your Lordship, here the mandating examination is considered as a requirement that every law graduates to be to fulfill, Your Lordship. Your Lordship.
But seen the time card also.
Much obliged, Your Lordship.
Consuming your co-counsel's time.
Much obliged, Your Lordship. Therefore, from the above arguments stated, the Council humbly submits that the amendment made by the Bar Council of India by mandating All India Bar examination clearance for enrolling as an advocate is valid, Your Lordship. Much obliged, Your Lordship. Third and fourth issue will be dealt by my co-counsel, Your Lordship. Council seeks permission to approach that.
Counsel, you are out of time.
Your Lordship. Your Lordship, and speaker number 2, on the behalf of the respondent, will be dealing with the issue number 3 and issue number 4. Your Lordship, issue number 3 is very much clear. Whether the amendment made to the Advocates Act 1961 are considered to be arbitrary. Your Lordship, we strongly deny that the amendments made by us is not arbitrary with the following contention points. First is that the non-violative of Article 14 and the satisfaction of the twin test of reasonable classification, that is the rational nexus and rational intelligible differentiation and the rational nexus, Your Lordship. Your Lordship, here the Article 14 states that the state shall not deny any person equality before the law or equal protection of the law within the territory of Sindhya, Your Lordship. Your Lordship, we have to quote the word, that is equality before the law, which states that absence of any special privilege. We do not provide any kind of special privilege to any kind of particular people, as we take lawyers as a common society and to appear before the ASB examination. Your Lordship, we also like to say that the intelligible differentiation and the rational nexus is used to classify the lawyers as the enrolled and non-enrolled in order to avoid the fake lawyers that has been given by the MOOT proposition, as the 30% of the people, fake lawyers has been identified. In the MOOT proposition, it has been very clear.
Skip over the fake advocates issue. Already several questions have been, she has also argued. You proceed to the 3 and 4 alone.
What's a blitz, Your Lordship?
Arbitrariness, they had cited something.
Yes, Your Lordship.
What's
Your
your
Lordship,
answer?
yes, Your Lordship. Your Lordship, the second question is that as the petitioners stated that we don't have any power to levy the fees. Your Lordship, this issue shall be dealt with 2 points. First is that the fees inadequacy, as the MOOT proposition is very much clear about the inflation rate of the current financial period of 2024 to 2025, that is 363%. And we also like to quote that
What is the need for the enrollment fee and other things?
Your Lordship, the council.
BCS is already having several funds, advocate welfare fund, clerical welfare fund, everything they are having. It's not a profit-oriented organization. You are serving this advocate community. What is the need for charging the enrollment fee?
Your
That's
Lordship,
what they are asking.
unlike other professional bodies, we rely only on single-time payment enrollment fees. As it is very clear, we only get.
So you want to profiting?
No, Your Lordship, it is not in the sense of profit. We are providing required services that has been.
Yes, already you are having several funds.
Council, the Law Ministry also has provided 20 crores, na?
Your Lordship, pardon, Your
Law
Lordship.
Ministry has also provided funds for the Bar Council.
Yes, Your Lordship, we promptly utilize the resources that is provided to us. Your Lordship.
It's also being allocated by the government.
Your Lordship, the council will be submitting a report by the bar and bench, which has been provided by the bar and bench, that we promptly utilize the resources. As per the report of the committee for proposing the scheme for implemented, we promptly provide the enrolled advocates with the insurance, with the medical claims for in certain
For each and
uncertain
every-
You are
situations.
surveying only from the fee collected from the lawyers.
Your Lordship, we get a single time payment. But Your Lordship, not to focus on the payment, we also like to cite the case that the petitioners has also questioned that the Commissioner Hindu Religious Endowment Madras versus Sri Lakshmi Trita Swamini of Srirur MOOT, which has been 1954 AIR page number 282. As per the compendium, it is page number 192, last paragraph, first line, which says that the authority of law can levy the fees in order to regulate, supervise, and to control all over the acts of the subordinate who is paying, Your Lordship. Here, we are not only stating about the services provided. We are indirectly, we are controlling, in the sense, in good terms, we are controlling the activities and also it has been stated in the case. And also, Your Lordship, it has been stated once again in the Secondra Hyderabad Hotel Owners Association versus the Hotel Municipal Corporation, AIR 1999, SE page number 635, page number as per compendium 169, last paragraph. It is very clear that we provide services and we also regulate the acts, and it is directly controlling the fake lawyers, as well as, Your Lordship, as the petitioners have stated, we are violating Article 19.6. No, Your Lordship, we are not violating Article 19.6 because we are only promoting the general interest of the people, and also we are having the right to keep the regulations for the qualifications, Your Lordship. Your Lordship, and they have also mentioned about the satisfaction of the quid pro quo.
By levying a huge fee, is it not making a dent on Article 19?
No, Your Lordship, here the council is pleading that we are giving the amount that is reasonable according to the inflation, as well as the petitioners have stated a word that is economically weaker section. Your Lordship, here we have to state the marginalized section, where we have to quote the amendments has been given to SC/ST, that is we have to pay only 2/3 of the amount, and we are not forcing on the marginalized section of the society, Your Lordship. It is very clear from the amendment we made. Your Lordship, as well as we have to consider this are the rules, and these are the cases that is satisfying the rule of quid pro quo. And Your Lordship, we have to consider the non-violation of Article 19. As we have already stated, Article 19 is providing 1G, is providing a basic right, as a fundamental right. Every person of India is having the right to practice the trade, profession, and occupation. Your Lordship, here we are not violating anybody's professional practice, as it is also very clear that we recommend and we also provide it as a statutory function, as it is also mentioned in Section 30 of our Act itself, Your Lordship. We respect it. And also, Your Lordship, it has been given in the Haniraj L. Churani versus Bar Council of Maharashtra and Goa. It has been given 1996 AAR, page number 1708. As per compendium, it is page number 49. Your Lordship, we say that a person who is performing the noble profession as a lawyer must work with his heart, soul, and body, all the thing. So we are not stating that he should completely give as a part-time job. As the Haniraj is also Haniraj case law is also stating that we can't ride two horses at the same time. So it is also we are also coming into that purview also, Your Lordship.
Please argue on the issue, Council.
Please, Your Lordship.
You are not in a public meeting.
Yes, Your Lordship. Yes, Your Lordship. Your Lordship.
But address the legal issues alone.
Yes, Your Lordship. Your Lordship, as well as we have to see about the non-violation of Article 21, which states that every person shall be provided with a life and personal liberty except to the procedures established by the law, provided it should be just, fair, and reasonable. Your Lordship, and as we satisfy this criteria of just, fair, and reasonableness, Your Lordship, here we make amendment which is in purview of the Constitution of India, as well as we respect the space of the UGC. We made the amendments, Your Lordship, as the UGC has lacked to perform their own duty.
The answer for the consultation process, they are saying that the UGC has not at all been consulted.
Your Lordship, Your Lordship, if it's so, the UGC has given a proper affiliation to the proper universities.
So they are not performing their duty.
Yes, Your Lordship, as the MOOT proposition is very much clear that they have given the universities recognition beyond our recommendation of BCS, Your Lordship. So it is very clear that they have failed to, so we are taking our power and as per the rules and regulations, Your Lordship. No, Your Lordship, we are not overlapping. As they fail, we do it, Your Lordship. We do not want the advanced consequences to be faced. Pardon, Your Lordship?
You are taking somebody's power and you are accessing.
Your Lordship, as it is in need, we do it, Your Lordship. Otherwise, there is no part of BCS to perform. But we have to focus, as they fail, we do it. It is our responsibility as a special body. We have our own independent and administrative right to focus upon the lawyers as enrolled, Your Lordship. Your Lordship, and we also have to state about the within the scope of the Parental Act. As the petitioners have stated, we do not have the right to perform all the kind of amendments. We have to state within the scope of the Parental Act, as per it is explicitly provided under section 49A, 1AH and D, and it is also explicitly stated in section 7, Clause 1H, that we have right to frame the standards of legal educational standards when it is required by the BCS. Your Lordship, and also we have to state that it is a special body as we have the, our own separate legal basis, purpose and functions. Your Lordship, the Council seeks permission to move on with issue number 4. Much obliged, Your Lordship. Your Lordship, issue number 4 is very clear whether the rules pertaining to the uniform standards by the BCS are violating the constitutional limits and principles. It will be dealt with the following contentions. First is that the general power of BCS. Your Lordship, it is very much clear that we already stated section 49, 1AH.
Your power is admitted by the petitioner, so you need not harp on your existence of power.
Much obliged.
It's on the exercise of your power. The query is, the moot problem is. Answer it as a respondent.
Yes, Your Lordship. Your Lordship, we'll be moving on with the master's degree as the petitioner stated. First is that the master's degree, Your Lordship, here we gave the importance to the 2-year LLM. The council seeks permission to move on. I will be proceeding. Yes, much obliged, Your Lordship. Your Lordship, as we have focused over the 2-year LLM, Your Lordship, here in the case of Tamanna Chand Chanchali versus Bar Council of India and others, civil number 70/2021, as per comparative page number 182, 4th paragraph, they are stating that to become an assistant professor, we need 2 years LLM and not 1 year LLM, and they have also stated if it's a person is pursuing the 1 year LLM, they additionally need a 6 months teaching program, because Your Lordship, here we are not only focusing about the 2 year LLM, we are also furtherly equally focusing about the NET and SET examination. NET and SET examination is priorly having a paper which is called as the understanding of students' psychology. A person who is having a complete ideology, it is very much clear they have to complete with the examination of NET and SET. But Your Lordship, there is an exemption that we made, is that the 10 years, the person who have practiced in the chamber for 10 years with the master's degree, in order to promote the practical knowledge to the people while learning itself. We state that they should be given with the concept of learning the practical knowledge. The petitioners have stated that the BCS will not be promoting the practical knowledge. No, Your Lordship, we are stating that the practical knowledge shall be given to the students during the graduation for the period of learning time itself. So that's why we are stating that the 10 years LLM, 10 years person who have practiced in the bar chamber shall also be provided as in they shall also be provided with the title of assistant professor for the practical knowledge. Your Lordship, and as the master's degree is very much clear, we have to move with the amendments that we made in the form of inspection and recognition. Your Lordship, the third thing to be addressed is very much important of the inspection and the recognition. Your Lordship, as we are very clear, and the bench have already submitted the BCS rules, it is as per Rule 9, Chapter 11, Part 4, and the Chapter 3 is explicitly giving the BCS with the power to inspect, recognize, and accredit the universities, Your Lordship. Your Lordship. Yes, Your Lordship. Your Lordship, as it is also furtherly stated that the funds are promptly utilized, as we only use all the purposes that is necessary by the BCS. Your Lordship, that's it, the arguments and the amendments made. Your Lordship, the council seeks permission to move on with the prayer. Much obliged, Your Lordship. Wherefore, in the lights of facts stated, issue raised, arguments advanced, and authority cited, it is most humbly played and implored before the Honorable Supreme Court of India that it may graciously please to adjourn and declare that dismiss the petition and also pass any other order that it deems fit and proper in the interest of justice, equity, and good conscience. Great argument before the bench. Thank you, Your Lordship.
With cost or without cost? You all along emphasize on the fund.
With the cost. Sorry, Your Lordship.
Your Lordship, the council would like to address certain issues raised by the council, learned counsel for the respondents. First being the Haniraj Cholani case. Your counsel, we are not actually contending the power of BCS in conducting ASBE. We are actually contending the guidelines or the procedure in which it conducts ASBE and how it fails to address the objective, Your
See,
Lordship.
if your contention is that you are not challenging ASBE, then your writ petition has to be dismissed.
We are not challenging ASBE, Your Lordship. The first issue states that the mandatory nature of ASBE is at fault, Your Lordship. That's the contention that we put forth, Your Lordship. The learned counsel for respondents has tried to misdirect it as our contention towards ASBE, Your Lordship. That is not the nature, Your Lordship. The current mandatory nature is what we are conducting, Your Lordship. There is a clear distinction between the mandatory nature of ASBE and the power of BCS to hold ASBE, Your Lordship. We have actually considered the power of BCS to hold ASBE, Your Lordship, from the case of Boni FI versus Union of India, Your Lordship. And the mandatory nature without proper guidelines and the removal of 2-year time period for their experience is making it invalid, and it does not achieve the objective sought by the by the Parliament, that is to improve the competency of the legal landscape, Your Lordship. Second one being there is violation of Article 14 and Article 19(1)(g), Your Lordship. Violation of Article 14 is clear and error apparent on the face in this petition, as there is no clear distinction between why there is a classification has been done between the pre-2024 enrolled advocates and the law graduates who are to be enrolled after post-2024 amendment, Your Lordship. And this creates an artificial distinction, Your Lordship, and such arbitrary artificial distinction is sufficient enough to violate Article 14, Your Lordship. Furthermore, Article 19(1)(g) is violated because of their excessive fee imposition, Your Lordship. They actually claim that there are 60,000 to 70,000 advocates enrolled in India per year, Your Lordship. And charging anywhere between 0 to 20,000 is only proving their profitable intent, Your Lordship, but not the intent to improve the legal landscape, Your Lordship. Furthermore, they have cited the case of Sri Lakshmidhara Tirtha Swami of Srirur Mutt, 1954, 1 SEC 412, Your Lordship. They have conveniently left out the point that has been stated after the contention that they put forth, Your Lordship. The traditional view that there must be an actual quid pro quo for a fee has not been applied in strict sense in the Supreme Court. The relationship between the levy of a fee and service rendered is only of general character and not of mathematical exactitude, Your Lordship. The meaning of the same is understood to be that the nature of BCS being a body and its service is to serve the advocates who are enrolled and to be enrolled, Your Lordship, but not as a service rendered upon paying of fees, Your Lordship. In that sense, it is a malicious intent of the respondent, Your Lordship, to take fee and argue that they are providing service for the same, Your Lordship, which thereby proving their malicious intent, Your Lordship. Furthermore, the contention stating net SAT qualification, Your Lordship. Your Lordship, it is essential to understand that net SAT qualification is mandated by UGC for junior research fellowship, Your Lordship. And furthermore, they have clearly stated that associate professors can be hired without net SAT qualification, Your Lordship, which they have conveniently left out, Your Lordship. Only assistant professor require the net SAT qualification and PhD, Your Lordship. That has been provided under the UGC rules 2025, Your Lordship. And the current mandate or the current amendment is trying to circumvent the same by stating the objective that they are improving the legal landscape and the professional by only taking qualified professionals. They are and addressing the issue of shortage of staff. They are actually discrediting their own argument, Your Lordship, by imposing such an amendment, Your Lordship. This amendment restricts the LLM graduates or any other graduates who want to pursue the legal profession into academics, Your Lordship, by imposing an artificial barrier, which the UGC has not mandated, Your Lordship. Furthermore, they have endorsed into the powers of UGC, Your Lordship. UGC is the superior authority regarding education, Your Lordship. They are the ones who are controlling who has to be the faculty and who has not to be faculty, Your Lordship. Just because there is a power vacuum doesn't mean that the respondents can take up suo motu action and fill it, Your Lordship. That's actually a culpable excess of their powers.
See, counsel, becoming a lawyer is one aspect.
Indeed, Your Lordship.
Practicing as a lawyer is one aspect.
Indeed, Your Lordship.
Correct? It is optional for a lawyer to practice an advocate.
Indeed, Your Lordship.
So therefore, why can't a bar council impose or by way of examination, their question is, their argument was only to find out the fake lawyers. We are conducting this examination to weed out the fake lawyers.
Indeed, Lordship.
So practicing, all lawyers need not be an advocate, practicing advocate. What is the answer for that?
Your Lordship, I would like to bring to the attention of the bench the referred document, pages 31 to 32 of bar and bench that has been submitted before the bench, that the new definition of legal practitioner, Your Lordship, there is a kind extension of 1 minute. The new definition of legal practitioner also includes alt law careers, Your Lordship. Alt law careers includes professionals who who only partly practice law, Your Lordship, such as chartered accountants with a law degree, such as forensic advisors with a law degree, etc., Your Lordship. These law degrees have been recognized under the new definition that has been recently amended by the Bar Council of India, Your Lordship. They are actually going against their own definition, stating that we are trying to weed out such part-time lawyers by imposing ASB, Your Lordship. ASB, Your Lordship, is only the objective of ASB was to test the competence of law graduates entering the profession, Your Lordship. However, the current format in which they are imposing ASB does not actually evaluate the quality of the lawyer, Your Lordship. And hence ASB is violated, Your Lordship. Hence the arguments raised by the petitioners does not stand chance, Your Lordship. Council concludes, Your Lordship.
What do you say for the net slut qualification alone? You address that issue alone.
Your Lordship, it is very clear that the petitioner stated about the net and set qualification. Your Lordship, the UGC has also addressed, they have also accepted the qualification that we set out as in net and set. Furtherly, Your Lordship, net and set is a criteria that in order to filter out the best teachers that should be provided to the law graduates. Your Lordship, here we also state that the practical knowledge should be provided. That's why we are keeping an exemption of 10 years thing, Your Lordship. Your Lordship, and I would also like to cite the differentiation that the petitioners has mentioned. There is a differentiation, the term of fees and the tax, Your Lordship. As the Tamanna Chanchan Chalani versus BCI, they termed that the taxes cannot be levied, but we levy the fees as per Article 110 of the Constitution of India. It is very clear that the authority of the law, authority of the concerned powers, they have the power to levy the fees as the service rendered, and satisfaction of quid pro quo is very essential, that we have satisfied. Your Lordship, as they have also mentioned about that there is no practical knowledge during the arguments, we also like to state about that the MOOT court and the inspection, the internships that shall be provided, it is completely under the curriculum to refer that. And Your Lordship, the court visit is also mandating in the final year, so the practical knowledge is not it is not completely ignored. And also, Your Lordship, they have stated that during the arguments itself, we have proved that it is non-violative of Article 14, 19, and 21. And Your Lordship, we have to keep a reasonable eye on the reasonable inflation that is to be coped up after the passage of decades. And also, Your Lordship, as a special body, we have the powers to frame down the standards of legal education and not the general body according to the legal maxim, Your Lordship. Great argument, Bill. Thank you, Lordship.
We are reserving it for orders.
Rise up.
He's a High Court judge.